Wakili Danstan Omari is our guest this hour. He's here with us in the studio. Good morning, Wakili.
Morning. Hi. I hope Wakili Murkomen has heard that message.
Kama hajasikia, tafadhali enda ukipatana na yeye ambia yeye.
Ni lazima.
Yes.
Ubaya siku hizi is no longer wakili, is waziri.
Is waziri wakili.
Wakili waziri.
Wakili waziri.
Sawa.
Sindio?
Lazima umesikia.
The thing that actually niseme kwa Kiswahili kinachodumu ni jina ya wakili, kwa sababu wakati itafika hata kuwa waziri tena,
atabaki na akili ya wakili,
hata kuwa bado ni wakili. Hiyo atazikwa nayo.
Yes. Lakini waziri
itakuja kuisha.
Ni wa muda.
Tena muda.
Yes. Wa muda.
Itakuja itaenda.
Lakini wakibadilisha katiba atakuwa waziri mpaka kifo. Unajua tulikuwa wakati wa Moi. Kwa hivyo kuna njia.
Hata wakibadilisha.
Kuna njia.
Wakili, welcome to Kenya's Biggest Conversation.
Thank you very much.
Good to have you here again. You're here because something is happening in the courts, and that is affecting President William Ruto's constitution of his government. Now, the president nominated 51 members to be his principal secretaries for the various state departments. Now, several interest groups have gone to court. The Law Society of Kenya is one of them. You represent some others going to court challenging the composition of these 51. Who do you represent in court?
I represent one activist called Frederick Bikeri, who is arguing that where he comes from, the county of Nyamira, representing the county of Nyamira, they were never considered for that end of those positions. So I represent one of the activists. There is the Law Society of Kenya representing under Section 4. The Law Society of Kenya is supposed to defend the constitutionality and the rights of citizens. Then there's another one, Dr. Magare from Nakuru. He's also representing he represents himself. So in total, there are 3 petitions as of yesterday that are challenging the composition of that 51 people.
Justice Makau yesterday released some order that is halting Parliament from continuing with the vetting of the principal secretary nominees. Was it a consolidation of all these applications, or was it just the application by the LSK?
LSK had, the first person who had filed is Dr. Magare. The matter went before a judge. The judge ordered Dr. Magare to serve. That was a petition filed on the 3rd. I did file another petition on 4th. These petitions were consolidated on Monday, and directions were supposed to be issued yesterday. In those 2 petitions, the Law Society of Kenya had applied to be an interested party, to join as to be enjoined. But before the judges could do that, on Monday, the judge who was supposed to sit to hear those matters was on official duty. The Law Society of Kenya filed a petition number 192 in the Constitutional Court, and therefore the orders were issued. Now, the directions of the court is that all the 3 petitions will be consolidated, and they will appear in court on the 21st of this month for an inter-parties hearing.
What is the main bone of contention with this petition?
The 51 Kenyans who are nominated by the president do not meet the constitutional threshold of how the face of the republic is supposed to be. One, the tribal diversity. Kenya has more than 46 tribes. When you look at the composition and you've looked at the Law Society of Kenya, argument is that out of 44 tribes, 2 communities, the Kikuyus and the Mount Kenya region and the Kalenjins constitute 13, that's 26, leaving less than 20 slots available for other Kenyans. That the angle of ethnicity is not catered for the diversity of ethnicity. 2, people who are the youth are not in that group. 3rd, the gender issue. There are 11 principal secretaries from the female gender against the male gender, that is 44. that is an inequality that cannot be contained. Remember, there is a contention that Parliament must have at least a third of gender representation. So we are challenging that the women have not been given the equal opportunity to be representative in the PS position. People with disabilities, that is another condition that the law, the Constitution demands that at least people with disabilities must make at least 5% of the composition of government. Then we have the marginalized communities. There are quite a number of marginalized communities. For example, small ethnic subgroups. For example, the Njems, the people who cannot, by numbers, they are marginalized. And that is the issue that we raised. And also the composition of the CSs vis-a-vis the PSs. So really, those are the constitutional thresholds that in Article 10, any appointment to government must be accountable to the Republic of Kenya. Any position in public service under Article 232 must reflect the face of the Republic. And there is also a ground that some two people never applied for the jobs. If indeed that is true, because we've demanded that Article 35 to be given the names of the people who originally
who sent in the application.
Surprisingly, Public Service Commission did not publish the names in the big newspaper called the Standard of all the people who applied. They only told us the people have been shortlisted. That anomaly is contrary to the provisions of Article 10. Failure to disclose who applied. 2 moves either. Then, remember, they extended the application the deadline to allow more people, representative, these marginalized groups and people with disabilities to apply. The numbers increased. 477 came in. After a day, it arose, 109 were added. The names that went to State House is around 200 people. The question is, which we are raising, inclusivity of every gender and every tribe. What was hard? The positions are 51. Why could the president not give each tribe one position? That is 44. Every tribe will have one PS, then 7 remains for him to deal with the way he wants to deal with them. So inclusivity is a constitutional question, and that is why the judge agreed with LSK and us that we need to deal with the constitutionalism of the Constitution, so that we don't have just a paper called the Constitution without the element of constitutionalism being put in place. That is the grave situation that Kenyans are facing today.
You know, this question of the youth always comes up, as with the gender balance. But when people apply for a job, such as the one we're discussing with the principal secretaries, there are basic requirements, I believe, that the Public Service Commission expects one to have. What are they in terms of experience and in terms of age?
In terms of age, is anybody above 18 years old. In terms of nationality, that person must be a Kenyan. Third, the other qualification is a degree, because that is purely an employment within the public service. It is not a political appointment. The youths have that. Age bracket of the youths is from 18 to 35. All the blue chip companies in this country, the CEOs are below 35. So when we talk about expertise, the digital era.
Which blue chips are you talking about?
All of who?
The majority of blue chip companies in the private sector
Okay.
are managed by people who are below 35. Globally, we are moving to the life expectancy age of us who are going to reach 100. The life expectancy age of young people is around 50. So by 35, if you've really not made it, it's not the time that you're going to look for a job at 70 years old. So that is the issue about the youth.
Let me ask the question, experience, because public service jobs, the question of experience always comes in as a requirement.
The experience question has always been used to marginalize the youth. The Kenyatta One cabinet of Mwai Kibaki, of
the whole
Matiba,
lot.
the whole lot.
Yes.
Were young guys.
Very young. In their
The
30s,
president of the Republic of Kenya, the 5th president, was a youth by the time he became a minister for agriculture. So really, let us not marginalize. It is a glitch that comes in when you want to remove the youth from the mainstream issue. People like Balala started being ministers, cabinet secretaries at the age of the youth. People like Wamalo. So really, we have experienced that it is no longer the experience. None of those people have been appointed other than the 4 or 6 former Uhuru PSs have had an experience as a PS. You can only have an experience as a PS if you have been one.
If you get the job, yes.
But there's experience
So-
in the public service.
That's what I'm saying.
Rising through the ranks as somebody who's been
Rising
in
through the
public
ranks
service.
is not an experience because there is no rank or you move up as a PS. You enter in public service either as a children officer, either as an accountant, either as a procurement. That does not give you the expertise or experience as a PS. The president of this republic, you do not have any experience anywhere to be a president of this republic. The only person who has experience is the retired president Uhuru. So William Ruto comes in without any experience as a president of the republic and is running the state without that experience. So let us not marginalize people that produce expertise, because expertise and experience can only be acquired if you have been given that job.
Okay, so let's look at the gender issue for a minute, and people talking about underrepresentation. Then when it comes to gender with these nominations, it wouldn't be the first time. We had a basically hung parliament through the entire tenure of the 12th parliament because it was not representative in terms of the 2/3 gender rule. The CJ Emeritus who said, look, everybody should go home. This is my recommendation to the president that you should disband this whole thing. That hung in the balance as well. So upon which threshold then will be used when we're looking at the nomination of these? The entire legislation of the country for 5 years did not follow the rule. How would things make a difference now with these 51 nominations? And we're saying that the gender balance, because again, it's one of the bones of contention for which the court must rule or not on this particular holding of the order. So what difference will it make now?
The issue that is very, very critical on the question of gender is that the legislative arm of parliament has completely failed to get this right. Within the manifesto of the bottom-up approach of Kenya Kwanza was that within a stipulated timeline, they will ensure within a year, they will ensure that the gender equality rule has been actualized. That is supposed to be starting from appointment position. Cabinet. Out of the 22 members of cabinet, only 7 were women. We expected parliament to represent us and reject that gender inequality. Parliament became a conveyor belt. Nobody went to court to challenge because every Kenyan hoped there is parliament that is representative, that understands the gender question, it will reject that number. After it became a conveyor belt, the next positions coming are the 51 principal secretaries. That is why everybody is now rushing to court, that we have no confidence in parliament vetting. Let us go to the courts so that the courts intervene. And the courts have intervened. The gender rule question is not a token. It is not a privilege for women or for any other gender to be given as a token. It is a constitutional right. It is a requirement that every person must comply with, and that is why the issue of gender now in appointments must start reflecting from the face of the principal secretaries. The question about the principal secretary, the functions of a principal secretary is the distributor of the national resources, financial. Cabinet is policy. The person who sits with the knife with the national cake to distribute whichever way in terms of finance and in terms of human resource is a principal secretary. That is why in the old constitution they were called permanent secretaries. Others are temporal. This position if women are not seated there, the distribution of the national resources will be skewed in favor of the men. And that is the reason as to why we are saying the right, that constitutional right must be upheld. We put the president and Kenya Kwanza to task. There was a conference at our stadium with the women, and they signed a charter. And the charter was the government of Kenya Kwanza, if it is formed, will be 50-50. What went wrong? What went wrong? The manifesto is there. We have annexed a copy of the manifesto. We have annexed the articles of the Constitution. We have annexed all international instruments protecting the women. So if we don't treat our sisters, if we don't treat our wives, if we don't treat our daughters as equals in this country, then where do they move? Do they move to Somalia or any other country? This is their country. They contribute taxes to this nation, and therefore they must be part and parcel of the national discussion of this country.
What's the hope that the courts will do? If we're going by historical experience, to say that even if there's a court order in place and that things will change as a result of what the court would or would not say, what is the hope? Because it is not prescribed. It's not that we can look into a book and we'll find what the formula is as per what the courts will do, and then we'll get the people to rejig the whole nomination process, zhuzh it up so that it now, meets the desires and aspirations of everybody concerned. What is the hope? That it'll send President William Ruto back to the drawing board?
This country cannot develop based on hope. Neither will this country develop based on somebody's goodwill. This country will be governed purely by the constitution of this country. Under the regime of President retired Uhuru Kenyatta, there was disobedience of court orders. In the campaign trail, even at the swearing in, the President of the Republic of Kenya, 5th President Dr. William Ruto, swore that he will defend and uphold the constitution. Among the pledges that he has given is to respect orders of the court. He has completely respected the orders of the court. Miguna is back. That was a court order. We have the 6 judges that had not been appointed. They have been appointed. That is a respect of the court orders. This is the first court order. We want to see whether he is within 61 days, he will have eaten his own words and said he will rule this country with impunity. The question is that our role is to get the court orders. We have gotten the court orders. Yesterday, vetting proceeded on because service had not been effected. We want to see, after service has been effected today, if the Dr. Halwales of this country are saying that that is hot air, it will be ignored, will then be, the question is, what then will be the difference between the old regime and the new regime? We believe strongly that the 5th president of this republic has no option. Let us put it that he has no option. He can only challenge. If we got a court order in the High Court, he can rush to the Court of Appeal or to the Supreme Court. The finality of court orders for now
is that vetting is halted.
For now, there will be no vetting today. But if vetting starts, then we'll be dealing with a new government that still is
But
not
remember,
respecting.
that is not the executive. That's not President William Ruto. You go and ask the Speaker of the National Assembly.
What we are saying, the Speaker of the National Assembly, the Chief Justice, and the President form the tripartite arm of government. If the Speaker, who is a lawyer, Senior Advocate Wetangula, decides to proceed, then the question is, that order is not only on vetting, it moves up to the swearing in. It is an order that runs in all the causes that are there. But we expect that the President will respect the court order, Parliament will respect the court order. The argument that a judiciary cannot interfere with the parliamentary business has been settled by the Supreme Court, that the custodian of the rights of citizens is the court.
Before we take a break, I just want you to be very clear. In the consolidated application before the court now, what are you seeking? Are you seeking that the courts declare the nomination of principal secretaries unconstitutional?
The prayer that we are seeking is true, That list is unconstitutional. That list is an illegality. That list does not meet the constitutional threshold. Therefore, a new list that complies with the constitutional requirement be put in place before Parliament vets them. That is the prayer Kenyans have sent us to take to court.
Okay. 8:30, lawyer Danstan Omari is our guest this morning. He's representing one gentleman from Nyamira County who has gone to court and says, you know, that PS nominees by President William Ruto unconstitutional. Case in point, nobody from Nyamira has been nominated. The Law Society of Kenya says it's not regional balance, there is no gender balance, persons with disability, youth not represented as well. Dr.
Magari.
Dr. Magari has also gone to court. Those three consolidated petitions out in the court, and the court has issued an order, first of all, just halting the ongoing vetting of principal secretaries. We want to understand why and get into the details of it.
This is the Situation Room, the only way to start your day.
Continues with Advocate Danstan Omari. The vetting of principal secretary nominees has been suspended by an order from the court, but also there are three applications before the court that have not been consolidated, just challenging the constitutionality of this nomination. Wakili, why in the constitution are you talking about this balance? So there is, regional balance, there is inclusivity, gender inclusivity in terms of persons with disability getting an opportunity, and the youth as well.
Kenyans, you can open at your constitution and start looking at Article 1, Article 2, Article 3, Article 10, Article 20, Article 22, Article 23, Article 47, Article 48, Article 51, 73, 1, 121, 29, 1, 155, 156, 6, 159, 161, 165, 166, 232. That is the most critical issue. 258, 1, 258, 2, 259. Those are the principles Wanjiku passed.
What do they say?
And all of them in summary, because many of the listeners of Spice will not be very lawyers by training, but they are lawyers because they learn a lot from SpiceFM, is that they say in any appointative position, at least 1/3 must be from the other gender. 1/3. It is compulsory. The judiciary itself is doing 50-50. 50 gender men, 50 gender male. Parliament has not met this threshold. What on earth should an appointative position require? Are there women who don't have degrees in this country? Are there women who don't have skills? Are there women who don't have those skills? So the constitutional threshold in all these, in Article 232, that is the public service, the article that deals with the public service, demands that the face of the Republic of Kenya appears in public service. Appears is the topmost job in public service. And that is why their employer is the Public Service Commission. That is the basis on which we are moving to court, that let the president comply with Article 232 on questions of public service and the face of the Republic.
Are we saying that if you look at PSS, then you just isolate and say PSS, you must have the provisions of the Constitution met just by PSS, and then you'll go to other appointive positions, ambassadors, that also must isolate, it must meet, look at CEOs of state corporations, isolate that also must meet? Or can you just say all of these are state organs, and if in totality there's gender balance, if in totality there's a face of the Republic in terms of the communities of Kenya, if in totality the youth are also represented, then you're fine?
From the lowest class of public service, job group A, that is the lowest, the cleaner, to the PS who is in job group T or S, that principle applies. The face of the Republic must be there. In the National Cohesion and Integration Commission and the act that are descended to that, every year public service must give to Parliament recruitment of public servants and serving public servants in terms of ethnicity, in terms of counties, in terms of wards. This is a requirement by the Constitution that if there is any form of imbalance, affirmative action must be put in place so that we have the regions that had never gotten any position to government being given a higher chance to recruit. The purpose of the women rep that came into this country was an affirmative action to ensure that we have enough women representatives in Parliament. So the role of, for example, the Minister for Gender, the Minister for Public Service, one Aisha Jumwa, is to ensure gender parity on any form of employment within the public sector. So this is not a token, as many people will think. It applies across board. And this is going to be very vicious in any appointment that is going to come. Article 35 of the Constitution mandates Kenyans to have any form of access to information on what government has. And among the issues people are raising, and right now, is we must correct those historical mistakes that some regions or some people or some gender were occasioned on when the old Constitution allowed the people the leeway. What I'm trying to say is that there is no accountability. There is no law that gives the president or anybody the power just to appoint anybody. Anyhowly. That story ended. The law provides.
Let me ask you, with the client that you're representing in court, his main contention is that there's nobody from his home county. Okay?
Yes.
Now, not tribe, but home county.
Yes.
So is the question about county, about region, about tribe, about clan? Because out of the 51, somebody would argue. In fact, I was having an interview with Senate Majority Leader Aaron Cheriot last night, and he said, if you look at the balance of the representation in the counties, this 41 counties are represented in the 51 nominations. Your argument goes into 13 are coming from North Rift, 13 are coming from Mount Kenya, but Mount Kenya is vast.
What we are saying,
how many counties are in Mount Kenya? How many counties are in North Rift?
My good friend, Senator was right. In terms of county representation, they have almost gotten it right. In terms of ethnicity, these are two similar. For example, Akisi living in Mombasa is appointed, that is Mombasa County. Akisi living in Kwale is appointed, that is Kwale County. Akisi living in Hola is appointed, that is Hola County. The Constitution is able to deal with that mischief. There is the county, there is ethnicity, there is gender, there is whether all these ingredients must be met.
So you want to look at tribe?
It is one of the conditions within the Constitution, because that mischief is what Kenya Kwanza has done, that we have 41 counties, we have only left 6 counties.
However,
it is not even right, they have only left 2 counties, Wajir and Nyamira, according to our data. In terms of cabinet, and PSS. They have left only 2 counties where Wajir and Nyamira have no cabinet minister and they have no PS. So the question my client is asking, when you do that simple arithmetic, which everybody is able to see without going to buy specs from China or Japan, are you really telling Kenyans that we are going to buy that simple story?
But Wakili, let me ask. In the Constitution and also in the laws that have been passed, does it talk about tribe or does it talk about...
The face of the Republic of Kenya is not... The face of the Republic of Kenya is in terms of ethnic, the diversity of ethnic regions.
So then, is it a mistake when the Public Service Commission only requires people to state the county where they come from?
Tribe is very critical.
Because the Public Service Commission does not ask you what tribe you come from. They ask you what county you come from.
You'll be surprised.
The Teacher Service Commission doesn't ask you the tribe.
You'll be surprised.
The military doesn't ask the tribe. The Police Service Commission doesn't ask the tribe. They only ask county.
if you read the national cohesion, the question of ethnicity is at the center of everything. When you talk about county, a county does not have one hegemony in terms of ethnic composition. A county like Migori has the Kuria, and you have seen them under Article 188 fighting to create their own county, because the question of ethnicity is the bedrock for rising to political or elective positions. The basis of political mobilization, which creates executive power in government, is a tribal question. And the Constitution looked at it. The face of the Republic of Kenya is in terms of ethnicity. The basis of others are the diversity of gender, diversity in terms of disability, diversity of all this. That is why Article 52 creates groups that are marginalized.
Yes, I agree. But is there any specific article, any specific mention of what we are discussing? Because beyond Chapter 3 on the preamble of the Constitution, we talks about proud of our ethnic, cultural, and religious diversity and determined to live in peace and unity as one indivisible sovereign nation. What we are saying seems to be extrapolated from many aspects of the law that we have, but there is no, at least as a layman, I do not know of any specific law that just deals directly with the ethnicity and the divisions and the inclusivity of ethnicity. Is there?
Read. You've forgotten the word ethnicity there. It is you who has implicated yourself. Read the preamble.
Proud of our ethnic, cultural, and religious diversity and determined to live in peace and unity as one indivisible sovereign nation. I'm speaking of the specificity. That's the word.
Ethnic is the
preamble,
number one.
Yes.
The preamble of the Constitution is what takes the tone of the Constitution. You've gotten it right. Kenya appreciated that we have a multi-ethnic diversity.
Yes.
And in the preamble, we are saying that we are proud of that ethnic diversity. Yes. And it must form the basis of any decision. Into every article, we must be alive to the reality of a difference of religious and ethnic background of Kenyans. Is this composition and alive to that? And cultural. Those three things, the whole of the Constitution, every article is alive to that. If we are not alive to the ethnic, cultural, and religious diversity, then we are a country that will not go anywhere.
If you are President Danstan Omari, Your Excellency, and you are nominating members to your cabinet and principal secretaries, and you're saying we isolate cabinet, you have a limited number of people who join that cabinet. How would you balance that ethnicity and gender and youth and persons with disability and minorities and marginalized and all that?
We have given
them into 24.
We have given a working formula. The positions are 51
for PSS.
For PSS, tribes in this country are 44. Get at least one. If you get somebody with disability from Yamira, get somebody of gender from Moranga. Get somebody. For example, when you look at the cabinet position, I know you've never gone to Moranga and got a constituency called Kandara. In Kandara constituency, it has two cabinet secretaries. Two. The Minister for Finance, the cabinet secretary for Finance, cabinet secretary for Water. One constituency has two. 289 constituencies are left to struggle to fight for 20 positions. Is it a fair representation? The question of resources, taxation is what runs a government. When it comes to KRA, tax is collected from everybody in this country. They have a right for representation. Karengata Association went to court and challenged the question of taxation without service. So the issue is, are you going to tax people from regions that are not represented in government?
Region, not
Either region, either community or gender. Are women going to say they will withhold taxes because they are not represented? This is not formation of a government, a political party. This is formation of a national government. And a national government, resources must be given even to those areas that never voted. But surprisingly, when you look at the political matrix, the voting pattern of the whole country, both Azimio and Kenya Kwanza got votes across board. Everywhere. Kenyans have a right. We are no longer in political agitation. We are now a country that is united, a country that everybody, the principle of equality of the law, and not feeling discriminated because you voted this way or because you are a woman or because you are this tribe. The question of equality of the law applies now. That now Kenya Kwanza must come to the reality that they are supposed to distribute not the Kenya Kwanza cake, but the national cake that is baked by taxes that are collected by every single Kenyan of this country.
You know, I hear when you talk about gender, because it's very clear. I mean, gender, it's male, female, and that's how we're looking at it. And so when you say there are only 11 women out of the many nominees, then there is an issue there that's clear to see. But the issue that I keep coming back to you on is this one of the face of Kenya and how you balance the face of Kenya. And you say you've done a bit of research. In fact, I'm just looking at this list of principal secretary nominees, and I know somebody who is the PS nominee for the State Department for Culture and Heritage is actually from Wajir County. And you're saying there's nobody from Wajir County who's been nominated either to cabinet or to PS. Wajir is represented.
I might be wrong if it is from Wajir.
This is from the list of principal secretaries. There? Yes.
The people are raising some fundamental questions. I've said some mischiefs.
The list, which I look both at...
Get me one from Nyamira.
Where they came from.
Where I'll file a petition against. Get me one from Nyamira.
So Nyamira is the only one. So not
I'm representing
not Wajir
a petitioner.
And Nyamira.
I've not filed on Wajir. I'm representing a petitioner who is challenging the composition that his county, you know, lawyers represent specific instructions from our client. His county, nobody has been.
I hear you. I was just challenging you on the fact that you said you have done your research and 2 counties are not represented at all in this.
I will counter-check that.
There are nominees also. I mean, there's a nominee who is a person living with disability in the principal secretary list.
What person is that? Why doesn't government put it very clearly that there is one? If they show us that that person is disabled, I'm a lawyer, I'll tell you, people will claim to be disabled on very flimsy grounds. Let them prove that. Once we see the evidence, because we sought that information from the Public Service Commission, they never gave that information. Now that they are going to file affidavits, they are going to bring ethnic profiling, they are going to bring to disapprove us. If we find that we are wrong, we are civilized people. We will withdraw the matter and say we are sorry. But for now, the perception is because they failed to give us information, the Public Service Commission failed to give us information, they'll bring that information to court. SpiceFM will have to have it, and we will counter-check. Is our allegations baseless or hot air, or is government's response cogent? Then the process will proceed.
The nominee who hails from Garissa County, let me just look for the photo, Abdi Dubat.
That is, he comes from Garissa. I have restricted my argument to my petition.
I'm on the issue of persons living with disability.
What is the disability there?
It's listed. You can go and check and count.
I will check. We'll check.
We'll check and count. How would you propose that a president constitutes government to have this constitutional requirement fully met, bearing in mind that the president appoints cabinet secretaries, the president appoints principal secretaries, president appoints ambassadors and heads of missions, president appoints boards of the various state corporations. President appoints, well, with the cabinet secretaries, president appoints the CEOs of, I mean, the boards appoint the CEOs as well, but the president appoints the boards of all these. How would you, propose that you make sure that the constitution is then followed to the letter?
Article 3 of the Constitution provides for mechanisms to check the executive. It is either through oversight of representatives in parliament, it is either the people themselves, we the people, or lastly, it mandates everybody in Article 3 to defend the Constitution. That removes the old concept of locus, where you could be asked, what is your interest in this matter? And that is why the constitutional and judicial review of the high courts have been created specifically to deal with Article 47. Is the president's decision a fair administrative action? If not, you have a right to run to court. That is different from the imperial presidency that we had under the old constitution, which didn't have checks and balances for the executive. Arbitrariness and impunity was the order of the day. So today, any Kenyan has a duty to defend the constitution. The media, the investigative approach by the fourth estate is one of the oversights created under the constitution to ensure that the media is free, the media is objective, and it investigates this matter. What we are interrogating here is properly put into oversight the role of the presidency. So there are very many tools available to Kenyans to ensure that their government is put to check. Failure by parliament does not mean that Kenyans have been left orphans. There are very many tools available. And remember, there are tools like impeachment. There are tools like recalling of members of parliament who have gone on recess without us knowing, failure to do their job. There are constitutional mechanisms. There's Article 37 that allows picketing and demonstrations. It is a whole bunch of procedures available for Kenyans. So Kenyans, let them not think that they are weak. They have no option. They will be heard, and the president will be compelled within lawful means. All that we are saying, the lawful means provided by the Constitution to oversight executive must be activated so that we have a proper government that is accountable to the people who elected it.
So that is the hope. Looking at these consolidated petitions, that is the hope that we'll go back to the drawing board and that the president should be compelled to retract this list of nominees and to then look at all these elements making up the threshold and then nominate based on those. Is that what we're saying the hope is?
Yes. For example, when we raised this petition, there was a PS, a principal secretary nominated from Kirinyaga lady, who was a wife to a sitting member of parliament. And that sitting member of parliament had nominated two sisters, one to Kiambu County Assembly and the other one to another county assembly. Out of the public pressure, that person withdrew and another person has been nominated. So let Kenyans not surrender. They fight to ensure that the constitution is given effect. Failure to ensure that we give life to this constitution, then it becomes an academic paper. It will be taken back to the shelves. So I don't come from the point of hope. I come from a point that there are enough instruments to keep this government compliant with Article 10, being transparent and accountable to the Republic of failure to this. Remember, 2027, it is a question of, is a referendum. Has government done exactly what it ought to do? It will be re-elected. If it has not done that, it will be fired. So the constitutional frameworks are in place. Let us not tell people like the religious people that let us hope. Let us follow the law as it is for now.
Danstan Omari, thank you very much for joining us. In 5 seconds, how long do you anticipate a court case to go on? Until a point when the president then is told, all right, you can go ahead and appoint or give us a new list?
Court processes.
Weeks, months?
Court processes advocates are not in control. There are very many parameters in it, but this is a very, very, very urgent matter that is going to be dealt just like election petitions. We hope the courts will deal with these matters very fast, but the layers available remaining is where the problem is.
Sawa.
The BBI took almost very many years to finish, because this is a matter Kenyans are ready to pursue to the Supreme Court. But we hope justice will be done, or the president will look and give a new face, and that matter ends. Let him reconstitute a new list, send
Sawa.
it to Parliament, and that matter is settled.
Danstan Omari, advocate, thank you very much for joining us.